Good evening and welcome to the August 28, 2019 meeting of the San Francisco Board of Appeals. President Rick Swig will be the presiding officer tonight. He is joined by Commissioner Daryl Honda and Commissioner Eduardo Santacana. We expect Vice President Ann Lazarus shortly, and Commissioner Rachel Tanner is absent tonight. We're going to move on to item number 5. This is Appeal number 19-070, Ron Ratner versus San Francisco Public Works, Bureau of Street Use and Mapping. Subject property, 2620 Laguna Street, appealing the issuance on June 12, 2019 to GTE MobileNet of California, LP, of a personal wireless service facility site permit. Construction of a personal wireless service facility in a zoning protected location. This is permit number 17WR-0252. And is that fine right there, Mr. Ratner?
Thank you very much.
Okay.
I think this will be fine.
Okay, great.
My vision is such that I'll be able to read my paper, but I may not be able to read the names of the commissioners.
Okay.
And I see that Vice President Lazarus isn't here. Maybe we can raise her from the absent, but I have her name written down in my presentation. So.
Okay, you can go ahead and begin, sir. Thank you.
Good evening. Welcome.
Thank you very much, Commissioner. Honorable Board of Appeal President Swig, Vice President Lazarus in absentia, Commissioners Honda and Santana. San Francisco has thousands of microwave antennas and cell towers, which until now have almost always been approved and have never been refused on health or safety grounds because 1996 FCC guidelines allegedly preempted all state and local U.S. health and safety regulations. This appeal is filed on unprecedented grounds that, contrary to alleged 1996 federal preemption, San Francisco has retained local health and safety jurisdiction over potentially dangerous wireless installations pursuant to its Precautionary Principle ordinance, as well as under the recent California Supreme Court T-Mobile decision, which upheld San Francisco's local regulation of lines or equipment on public rights-of-way that might cause negative health consequences or create safety concerns. Precautionary principle is a universal law of morality, like the golden rule, which pertains to every adult everywhere. Just as we don't harm others in ways we don't want to be harmed ourselves, we don't harm our precious planet's environment, because what we do to it, we do to ourselves. Surprisingly, despite international recognition of the precautionary principle, the city and county of San Francisco is the only world metropolis and the only large U.S. political entity which has legislated the precautionary principle as its official environmental policy. San Francisco's environmental code applies the precautionary principle to all San Francisco officers, boards, commissions, and departments, including public works, health, and planning departments. It also applies to this board's consideration of environmental health and safety issues. In approving a cell tower site permit at 2620 Laguna Street, the Article 25 city departments violated the clear language and intent of the precautionary principle ordinance in numerous respects. For example, their decision-making process for approving the cell tower was not made in an open and transparent manner with public participation. Instead, the permit approval was decided during an 18-month period of private communications between city departments and Verizon attorneys and engineers, which completely excluded any required citizen participation or notification. Before deciding to grant the permit, they failed to inform the public about potential human health and environmental dangers of the proposed cell tower. Instead, they invariably accepted biased health and safety opinions of Verizon engineers and attorneys without consulting independent EMF experts to evaluate dangers or need for the proposed cell tower or possible alternatives like fiber optics, which can now provide fastest internet in the USA. Instead of placing the burden of proving health and safety of the cell tower project on Verizon, its proponent, they improperly foisted upon vulnerable adjoining residents and owners the unfair burden of challenging health and safety of the agency's predetermined private approval decision. They failed to acknowledge or inform the public that thousands of highly credible, independent, worldwide scientific studies have overwhelmingly contradicted and invalidated 1996 FCC thermal safety guidelines, which have become completely outdated and extraordinarily dangerous. Independent studies have long shown that microwave cell towers cause cancer clusters and many other diseases and may seriously or irreversibly threaten not just San Franciscans, but people and nature everywhere. Thus, for many years, not even Lloyd's of London has issued product liability insurance on cell phones and Wi-Fi products. Too dangerous. And wireless industry corporations like Verizon confirm those dangers in mandatory SEC disclosures to their shareholders. So, in improving this cell tower project, the Article 25 city departments violated the most fundamental precautionary principle that, quote, where threats of serious or irreversible damage to people or nature exist, lack of full scientific certainty about cause and effect shall not be viewed as sufficient reason for the city to prevent the degradation of the environment or protect the health of its citizens, close quote. In San Francisco, this Board of Appeal is the last hope for most ordinary people. Hardly anyone can afford to litigate against giant corporations. So tonight, you have an unprecedented opportunity of conscientiously reversing a cell tower permit on health and safety grounds. Such a conscientious and groundbreaking Board of Appeals decision can lead San Francisco and our nation in protecting against further imprudent use of dangerous wireless technologies which seriously or irreversibly threaten not just San Franciscans, but people and nature everywhere. Thank you.
Thank you.
Thank you.
Thank you.
We will now hear from the attorney for the permit holder.
Welcome back, Counselor.
Good evening, Mr. President, members of the board, Paul Albritton, outside counsel for Verizon Wireless. We're sympathetic, obviously, to Mr. Ratner's concerns about the health and safety. Thank you very much.
Yeah, exactly.
That was excellent.
This is going to be a nice evening.
Yeah, I'll try and make it just as quick.
That was wishful thinking.
And I think you know Article 25 is one of the most robust regulations really in the country for these types of facilities to be placed in urban environments. Article 25 was upheld by the California Supreme Court in T-Mobile versus San Francisco. And Article 25 requires a very rigorous review of the public health of the emissions from the Verizon Wireless facilities. And for that reason, you know, we submitted a Hammett and Edison consulting engineers report, and we have a representative from Hammett and Edison here, if you'd like to ask any questions, that shows that the emissions from this facility are less than half than that of what is allowed under the FCC standards at the nearest building. The Department of Public Health took that report, which Hammett and Edison is an approved engineer by the city of San Francisco and also represents other cities, and confirmed in their report that this site will comply with the FCC standards, thereby complying with Article 25 and complying with the federal law, such that that issue is resolved with respect to the city code and resolved with respect to the federal law. Part of our obligations include the initial reporting here and to the FCC, and then subsequent post-installation testing, which will be done in order to absolutely confirm that the emissions from this facility comply with the FCC standards. The city and DPW in its brief included an announcement from the FCC earlier this month that they are reconfirming the same levels of emissions that have been in place for the last decade or so. We would argue that this really has been a public and transparent process, not a secret process. I think you are aware that there are notices that go out to allow for a protest hearing with the tentative approval. That includes the DPH and H&E Hammett-Nedison information that's available from the department as well. There's another notice that goes out with the final determination that allows 2 levels of protest before a public hearing officer and then here again. So we feel that it's a very transparent process. So we encourage you to approve the facility as approved by the Department of Public Health and, of course, reviewed by the Department of Planning and the Department of Public Works, 3 departments that have recommended approval of the site. And we're here to answer any questions you may have. Thank you.
I've got a question, Counselor, and thank you.
Yes.
Can you explain the difference between this antenna and the antenna that's generally before us? We usually are hearing the ones that are on the pole top. This seems to be a more robust system.
Yes. So as you've heard me go on before, right now Verizon is using 3 different types of radios in San Francisco. The site that will be coming up later is on a light standard, and that's a 5-watt radio. And then generally on utility poles, we're using 40-watt radios. These are the same 2 40-watt radios that we're putting on every utility pole in, we have 70 in North Beach and elsewhere throughout the city. We have a 4-foot antenna, and that's the same 4-foot antenna that we're using. It's a 3-directional antenna. The difference here is that we're using only one of the directions. And because of that, the radio signal is then concentrated in that one antenna, which is giving it a higher effective radiated power than you would have if you split the signal between 3 antennas. I spoke to the RF engineer, and she explained that this is a very cluttered environment. If you look at the photo sims, you'll see there are very tall buildings all around this pole. We're able to get up to nearly 60 feet with this pole, but the antenna itself is focusing uphill, up Laguna Street, to try and provide up Laguna and get through this urban clutter in providing its signal. So the site is not focused in 3 directions, but 1. So it's really the same radios, same antenna, but the fact that the energy from the radios is being focused in 1 direction rather than 2 or 3 directions, which is more typical.
The primary, sorry to interrupt you, Counselor, was that in the appellant's brief, they had stated 7,000 watt. Is that correct?
That's right. That's taking, and I can have the RF engineer better explain, but you've got 2 bands, PCS and AWS, which are the shorter bands, but that carry more information. And you have that 40 watts times 2 times the gain of the antenna, which is approximately 15, gets you to the approximately 7,000 watts. But that's 60 feet up in the air, and it's as the closest, the highest emissions are not actually in front of the antenna, but off to the side at the building that's about 12 to 13 feet away.
And then the other question, Counselor, was they had mentioned the April 4th, 2019 decision regarding T-Mobile West versus San Francisco. Just for my information, could you go into that a little bit as to what, since it was referenced?
Absolutely.
Thank you.
I'll try and be brief. So I was going to start with a long story. I'll go with a short story. The industry worked in with Article 25 was adopted. The final iteration of Article 25 was adopted in 2015. It was the 4th iteration of Article 25, and there had been suits by other companies. Verizon and AT&T worked with the city to come up with something that they thought was workable and led to the now over 400 facilities that Verizon has in San Francisco. T-Mobile, Extenet, and a company named NextG that was bought by Crown Castle were not comfortable with Article 25, and so they sued. And the principal argument was that under California Public Utility Code Section 7901, cities could not regulate aesthetics. that they could only regulate, under 7901, a telephone corporation has the right to put equipment on telephone poles and in the right-of-way. And they argued that there was no control over aesthetics, and they lost that argument. Article 25 went through from the lower court to the appeal court to the Supreme Court, each time T-Mobile and lost. But they pushed their case, and the Supreme Court said, no, cities do have their full police power to regulate the aesthetics of the facilities in the right-of-way, subject to the compulsory right of telephone corporations to put their facilities in the right-of-way. So you can't block a telephone corporation from putting its facilities in the right-of-way, but you can regulate the aesthetics. And that's basically the ruling in that case. But what it did is it upheld Article 25. So what was upheld is the zoning protected standards, the planning protected standards, the historic standards that you have in Article 25, that you can't significantly detract from the defining characteristics of the neighborhood, that you can't significantly impair the aesthetic attributes to create a historic district or an average or excellent view, because those are average, excellent view, those are all standards, objective standards that we can work with, and that's what was upheld by the Supreme Court.
Thank you so much, Counselor. I appreciate that.
I'm sorry I went on too long.
No,
Thank
that
you.
was actually very important. In all the cases
Thank you.
we've heard, I've never heard the term precautionary principle. Can you explain how that would affect your department and your decision going forward?
Yeah, so the precautionary principle is sent out for all city agencies if there's a health reason, a public health hazard maybe that could be looming. We do have a lot of hedges for that we use in Article 25. For example, where there's a CEQA process that's required. We have them submit a radio frequency study and a noise study that meets the public health compliance standard, which is reviewed by the Department of Public Health. After they install the facility, do have to submit a post radio frequency study, which is also reviewed by the Department of Public Health. And for whatever reason, there is a need for us to inspect the facility, we can have the Department of Public Health inspect the facility to make sure it's still within compliance.
Okay.
Is
Thank
the
you.
Thank you. Individual from the Department of Public Health here to testify, please?
I believe Ms.
accept
Callywort
questions?
is here. Would you like her to speak?
Sure. Before yourself, sir. Sorry.
Sit down, Scott. I'm just kidding.
I have a question for you.
Before we start, good evening and welcome.
Thank you, Jen Callowart.
In the spirit of precautionary principle, we have sent copious amounts of information to the Department of Public Health, this board. We have, and when I say copious, that little pile of paper I held up honoring Mr. Cantera, that's nothing by comparison to what we have sent you. There is data on data on data on data on data that has been presented by the public to indicate that every time we put a transmitter up, that it is causing health and harmful to the health activities to the public. In that spirit, and we are not scientists, we're not physicists, we're not engineers, we are also members of the public. But in that spirit, and to guard the public safety, we have sent this information to the Department of Public Health, and we have requested to the Department of Public Health an update on their 2010 position on the health and welfare to the public, or lack thereof, from the installation of these things. And that was several months ago. When are we to expect the response from the Department of Health after giving you all this information provided to us from the public that indicates that we're poisoning the public on it whenever we take an action to approve these transmitters?
Thank you. Yes, we did receive the request through Dr. Aragon, our health officer. He has received the request to respond to the 2010 memo that was written by the former Environmental Health Director and Health Officer, Dr. Rajiv Bhatia. So I have met with Dr. Aragon, and he is currently reviewing the documents, as well as doing his due diligence and research. And we will be able to create an updated memo similar to Dr. Bhatia's to respond to the current research and the Department of Public Health's position on radio frequency emissions and the standards that are set right now by the FCC, and to say if there is any concern or any health effects for those.
Okay, and when?
I would anticipate within 3 to 4 months. That was, roughly an idea through some conversations with him, and I think that that's totally doable. Like you said, I've seen the stack, and I agree. It's a lot of information to go through, and we have to be sure that we're looking at research that is connected to the cell-based antenna research. It's also repeatable, done through peer review. So there's these checklists that we have to go through. And Dr. Aragon is committed to making sure that he's thorough in that. So it is going to take him some time with his schedule and the large task of doing it and the research review. But I think that I can estimate, 3 to 4 months is doable for him.
Okay, you can understand our sense of urgency because week after week after week after week, we have these hearings. We have members of the public like Mr. Ratner come up and address very important items. We have others. Again, you didn't get that stack from us. It came through from the public, and they have a significant sense of urgency because their health is at stake, and we on this board are very concerned with the health of the citizens of San Francisco as a result of the installation of these items, and we want to put to rest. And we are governed by the law, and we'll talk about that later. But at the same time, the precautionary principle weighs heavily on our minds because we don't want to continually move something forward knowing that we may be causing harm to the citizens.
Yeah, I understand,
So
yes.
Your
I
sense
think
of urgency, I hope you hear our sense of urgency and also
Absolutely.
our sense of helplessness because we are not doctors, physicists, engineers, or scientists.
Yeah, and we as a department, we're not doing the research as well. So it is timely that the FCC made its announcement that it's proposing no changes through the 6-year opening public review comment. And we're definitely going to be diving into the research that they use to make that determination so we can see the validity of that.
Yeah, and in San Francisco feels otherwise, other than the FCC feels, which San Francisco quite often feels differently than the federal government feels on certain items. I hope the city of San Francisco takes the initiative to challenge the FCC on what might be an obsolete and archaic point of view in 1996.
Well, yes, and they definitely are not the ones that are the scientists. They're heavily relying on health organizations and the American Cancer Society research and the World Health Organization, as well as the FDA.
Thank you very much.
Thank you
for answering those questions.
Yep.
Thank you.
Thank you
for your hard work.
Thank you.
Thank you. Is there any public comment on this item? Okay, please approach the microphone.
And welcome.
Hi, thank you so much for allowing me to speak. I'm going to speak sort of off the cuff, if you will. There is enough research to show that electromagnetic radiation affects not only human cells, but it affects wildlife, it affects birds, it affects bees and butterflies, trees. I'm not a scientist, I'm not an environmentalist, I'm just a very conscientious human being, and I believe strongly that if we don't, as a human race, make decisions to protect everything that we're involved with, the environment, our air, our oceans, the wildlife, we are going to be in deep trouble.
Thank you.
Thank you.
Thank you. Is there any other public comment on this item? Please approach the microphone.
And welcome back, sir.
Thank you. Hello, board members, and hello, President Swig. I'm just going to start off this way. These are the times that try men so. And of course, so began Thomas Paine's letter to George Washington at Valley Forge the winter of 1776, and preserved the fight for independence and freedom. And we are faced with a crisis right now of extreme danger. Doctors, medical societies, social organizations, telecommunications specialists, They all recognize the harm being visited upon us, upon all ages of people, by Wi-Fi and its extreme proliferation and economic hazards. As this continues forward more deeply, every person in inconceivable ways, the very existence of the very essence of protection of the general welfare of society is being abrogated. Government has a mandatory role to protect society, and government must not choose a separate role of its own in armor of legislation. The Federal Telecommunications Act of 1996, Article 25, basically has engineers deciding whether or not something is harmful. They are not really looking at the World Health Organization. They are not looking at, there are many medical societies, the American Medical Association as well. Everybody is saying medically this is a danger. It was only affecting approximately 10% of the population 10 years ago. Presently, all the research I've read says that it's affecting 50% of the population. As it continues, it can dramatically affect more people. I just want to read you something real quick here. In the largest settlement for an electromagnetic injury ever recorded, the Boeing company will pay more than $500,000 to one of its employees who claimed that he developed leukemia during his work with electromagnetic pulse radiation. Boeing was charged with knowing about the health risk of EMP exposure, but failed to warn its employees and not taking any precautions to protect them. Anyway,
You have 30 seconds, sir.
the court ruled in favor of the client, and this was done in 1990. So keep in mind that in 1995, the Office of Technology Assessment was defunded. In 1996, we ended up with this. How Big Wireless made us think that cell phones are safe, a special investigation.
Thank you. I'm
Okay,
very
sir,
sorry.
your time is up.
All right. And
Thank you.
the Capturing Agenda
Yeah.
Agency
Okay, sir, your time is
okay,
up.
Thank
from,
I would appreciate
from
it
Harvard
if you-
University. And thank you very much.
Thank you.
Sorry to go over.
Thank you.
Thank you.
I want to thank you all, commissioners, because I can tell you've been really listening, and I really appreciate it. And I'm going to cut some of what I was going to say out just because really you're focusing finally on health. So I want to address that. So I want to present a metaphoric story. Timing is an important variable when climbing Mount Everest. Climbers must begin their ascent on time and must observe strict turnabout times. If they don't reach the summit by 2 p.m., they must turn around, or the afternoon blizzards and early darkness will bring certain death. Despite this knowledge, many climbers continue to the summit and never make it home alive. Christopher Case, an organization expert, states that we can be lured into destruction by our passion for our goals and make it a part of our identity, and it becomes increasingly difficult to change direction. People, despite accumulating evidence that the goal is unwise, our determination and commitment to continue becomes hardened. The FCC did not begin their climb on time. They failed to order 5G precautionary health and safety tests. They relied on the 1996 Telecommunications Act, an illegal law based solely on industry-sponsored health studies. The fact that Congress passed this law demonstrates regulatory capture at best, or outright corruption and fraudulence on the part of the federal government and the telecom industry. The climb towards 5G has been more arduous than expected. Throughout the world, citizens are pushing back. Cities and counties in California have passed ordinances banning 5G. Here in San Francisco, there have been 400 appeals against 5G permits with testimony from numerous key, very smart people, according to Rick Swig, president of the Board of Appeals here. Think about it. Who in their right mind would want a cell tower in front of their residence? It's 5 minutes to 2. Are you going to turn around and start your descent? Or is 5G going to become a suicidal mission for the people of San Francisco? Already you have asked the director of the San Francisco Public Health Department to read studies compiled by Dr. Joel Moskowitz. UC Berkeley public health researcher. And they responded today, and if it's going to take them 3 or 4 months, I still say there should be a moratorium on any more permits. And now Ron Radner has given you a reprieve by citing San Francisco's Precautionary Principle ordinance. You have been given the legal means to stop granting 5G antenna permits. It's 5 minutes to 2. Follow your heart and intellect and take the road less traveled. Thank you.
Thank you.
Thank you. Is there any other public comment on this item? Okay, seeing none, we will move on to rebuttal. Mr. Ratner?
Some people are frequent flyers, and I've been a frequent flyer.
Sorry, sir, it's hard to hear you. If you could speak into the microphone, please. Thank you.
Honorable Commissioners, I respectfully conclude with these verbatim excerpts from the Precautionary Principle Ordinance, which are not preempted and not discretionary. Quote, every San Franciscan has an equal right to a healthy and safe environment. All officers, boards, commissions, and departments of the city and county shall implement the precautionary principle when conducting the city and county's affairs. One of the goals of the precautionary principle is to include citizens as equal partners in decisions affecting their environment. Public participation and an open and transparent decision-making process are critical to finding and selecting alternatives. The community has a right to know complete and accurate information on potential human health and environmental impacts associated with the selection of products, services, operations, or plans. The burden to supply this information lies with the proponent, not with the general public. Based on the best available science, the precautionary principle requires the selection of the alternative that presents the least potential threat to human health and the city's natural systems, including the alternative of doing nothing. Where threats of serious or irreversible damage to people or nature exist, lack of full scientific certainty about cause and effect shall not be viewed as sufficient reason for the city to prevent the degradation of the environment or protect the health of its citizens. There is a duty to prevent harm. Close quote. I haven't yet met a single San Franciscan who wants to live next to a cell tower. So this is a crucial time for this board to at long last stop rubber stamping Article 25 cell tower permits based on long outdated and scientifically negated FCC health guidelines, which help the wireless industry but seriously harm humans and our precious environment. It is especially urgent now since we're imminently threatened by planned 5G microwaves to be beamed from antennas everywhere and even from drones and satellites. I respectfully urge this board to protect the health and safety of citizens by following the precautionary principle ordinance now and thereby honoring your conscience and your public duty to prevent further serious environmental harm. Thank you very much.
Thank you, sir.
Thank you.
So, given that the standard for the equipment has changed so drastically in recent years, why isn't there something that is in 2013, my daughter was still in third grade. Right?
2013,
so,
I think I was somewhere around there.
Exactly.
Let's see. So the reason that they don't update the standard every time there's not a new generation is because of the FCC standard isn't based on generation.
Mm-hmm.
Back in 1996, we were just around 2G area. But the standard is based on frequency, the actual part of the electromagnetic spectrum that the cell carriers operate in. And that frequency covers 2G, 3G, 4G, 5G, and presumably on and on into the future as we use the radio frequency spectrum.
And it's based on physics and our understanding of how electromagnetic waves affect the human body. And because of that, there's not a need to update the standard every time there's a new generation, because that's how the telecommunication companies modulate the actual frequency to send signal. But the frequency itself is a fundamental physical part of the electromagnetic spectrum.
I'm sorry, I'm going to stop you there because I'm not a scientist, and that's a little more than I bit off here. But okay, I got the gist of it. Thank you very much. Thank you, Counselor.
If I can, in 5 words, the frequencies stay the same. The technology modifies how the data is carried by the frequencies, but the frequencies stay the same.
Okay, thank you, Counselor.
Mr. Albritton,
Yes.
you throw the IIEE name is thrown about. Can you clarify? IIEE is a lobbying organization which represents the electrical engineers of this country, as opposed to a health and welfare organization.
So IIEE is actually kind of an old name. Nowadays, they just go by IEEE. IEEE is the Institute of Electronics and Electrical Engineers, and it's just a professional engineering organization. Most engineers are actually...
and it's for the benefit of supporting the electrical engineers.
Well, they're a standard-setting body. They bring together the expertise of engineers to set standards.
But their self-interest happens to do with electrical engineers and the promotion of that industry.
Well, as a professional engineering standard, as a professional engineering body, the first tenet of a professional engineering code is the health and welfare of the public. So that they probably would not say that.
Okay, thank you.
Commissioners, this matter submitted.
Why don't we let our new commissioner start here? Because I want to hear I'd like to hear his input as far as from law background.
Sure.
Sorry to put you on the spot.
No,
there.
that's fine. I was just refilling my water here.
Yeah.
Well, there's a couple of legal issues that have come up. Obviously, I'm not here in capacity as a lawyer, but I have reviewed the T-Mobile case, and I think that our discretion here is circumscribed by federal preemption. I have sympathy for the concerns of the public, and I think those concerns need to be directed at the federal government until the California Supreme Court changes its mind.
Okay.
Thank you.
Thank you.
So, thank you. That was really good, because that's exactly what the bottom line is here. We can sit here all day long, unfortunately. What I would like to do, and I won't be able to do, is I'd like to put this case on hold until the DPH comes up with their findings. I can't do that. I've been advised by the city attorney.
We can't?
That would not be a legal act, and we would probably find ourselves in court, thanks to Mr. Albritton, who I respect, and he has to do his job. And so I really throw the burden on this to the Department of Health to do their homework and come back and look the citizens of the city of San Francisco in the eye and say, these cell towers, all of these installations that are being put forth, but whether they be by Verizon, GT Mobile, AT&T, they're all healthy, and don't worry about it, kids. If they don't find it that way, to stand up and make San Francisco a leader in maybe telling a truth and that isn't being told according to research that is being provided by many of our orators here, whether they be the appellants or they be the public commentators. But at that point, maybe the precautionary principle will be invoked. But at this point, unfortunately, as much as I would like to place a moratorium as suggested by one of our public commentators, we cannot do that. The law prohibits that, and we are held to the standard of Article 25. And unless one of my fellow commissioners flying in the face of our first commissioner's commentary wants to move otherwise, I think that we have to deny the appeal based on the fact that the permit was properly issued under the code and under the jurisdiction of Article 25.
Okay, so as the commissioner that's probably has been on here before anyone else here tonight, I've heard the most cases, and unfortunately, to kind of answer what the appellant said, we have gone against many of the cell towers that have come before us. Some successfully. Most of it has gone to litigation, at which point this body has lost. It's not that we're scared to go forward. It's not that we're rubber stamping it, because that's far from the case. We spend hours reading these briefs. We all have jobs that we do for our real money. We have children, we have families, and yet we spend hours and hours a week going over these briefs, trying to make sense of all the scientific, the appellant side, the scientist side, the permit side. I've been on this body when we made those decisions and got litigated. And so I am extremely sympathetic. So much so that even I am tempted to continue this case. I don't have the votes here tonight, so that's probably not going to happen. But this body has requested from the San Francisco Health Department to produce some new numbers. Now, at which point, whether we like those numbers or don't like those numbers, those are going to be what we're dealing with. And again, nobody wants to have a cell tower 8 feet from the window. We've seen them as close as 4 feet. We've seen tons of wires. I mean, we literally have had hundreds and hundreds and hundreds of cases come before us with as many concerned citizens as you are today. Unfortunately, as my new colleague has said, not trying to be chicken shit here, but our hands are tired. I mean, they
on TV?
I just did.
Please.
I'm sorry, ma'am. And so at this point, I'm going to defer to what was said here by my other colleagues, and hopefully that in the near future, I mean, remember when they told San Franciscans that we were crazy because we recycled? They told us we were crazy because we're banning plastic bags. They told us that we're crazy because we're not using single-use straws anymore. And now look where that's going. So hopefully in the near future, we'll have a better outcome here.
My motion stands.
Okay, so we have a motion from President Swig to deny the appeal and uphold the permit on the basis that it was properly issued. On that motion, Commissioner Santacana?
Aye.
Commissioner Honda?
Aye.
Okay, so that motion carries. Item number 12 3-0 is appeal number 19-069, Ruth Krumbar versus San Francisco Public Works, Bureau of Street Use and Mapping. Subject property is 428 Amatory Loop, appealing the issuance on June 18, 2019 to GTE MobileNet of California, LP, of a personal wireless service facility site permit, construction of a personal wireless service facility in a planning protected location. This is permit number 18WR-0372, and we'll hear from the appellant first.
Good evening and welcome. Thank you for being patient with us. And you're lucky 4 cases got off the books tonight. Otherwise, you'd be here for another 2 hours.
Thank you.
Keeping us company because we love to be here. So welcome.
So we're, just for clarification, we're all kind of presenting together. So
Okay, you just share the time. Be cognizant of the clock. You'll have 7 minutes to present and then 3 minutes in rebuttal. So go ahead, whoever wants to speak first.
And there's a clock right in front, so.
Okay. Hello, my name is Ruth Krumbar, and I live at 2638 Lion Street with my teenage son. This is a historic Lion Street corridor, which is home to us. It's also enjoyed by San Franciscans and tourists all day, every day. I'd like to highlight a fact. The address 482 Amatory Loop being used for the proposed installation is deceptive. Here's why. 428 Amatory Loop is actually 2 miles away from the actual location, which is on Lion Street. If you Google it, you'll see that a location deep in the Presidio comes up. All communication to neighbors and the San Francisco general public about this issue has used the address 428 Amatory Loop. Verizon and the various parties associated with this have acknowledged the address problem and argued that there's been sufficient time for neighbors and the public to understand the truth. They've also indicated that under Article 25 of the Public Works Code, they've fulfilled their obligation to inform, and we dispute this. To highlight this point, they say 12 residents have communicated with the DPW. If you count the number of people within 300 feet of the location, there's a lot more than 12. We learned recently that some neighbors have just begun to understand where this installation is going. They thought the mailing was a mistake, as we initially did, and we believe others have no idea of the actual proposed location. In summary, we believe that they conveniently chose to use this deceptive address for the location of the cell tower to confuse the public and neighbors and to get away with placing something in one of the most historic and visited sites in the entire city.
Overhead, please.
Hello.
You're welcome.
Thank you. My name is Jean Newman. This facility that in the view, this is the Lion Street corridor. We call it the Lion Street Steps. It is one of San Francisco's most popular tourist and visitor landmarks, and it's also an area that I've lived in. I moved there originally 50 years ago, and I now own the house at 2626 Lion Street. So this facility is going to be 50 feet in front of my house. On the other side of the street, it's on the outside of the Presidio, right on the street, and it is obviously not 2 miles from the address that they had listed on that Ruth was talking about. I've lived there over 15 years. I love living there. It's beautiful, as you can see. And this facility would be built in the heart of this beautiful Lion Street Steps neighborhood. We're thinking that if this project, which has been rubber stamped, as it appears, is an ongoing process, I feel personally that it's fraudulent and deceptive and disingenuous. And by this process, it appears that it's been routinely approved and not taken into consideration the unique aspect of this popular and beautiful part of San Francisco. I witness every day, 365 days a year, a flow of people, neighbors, visitors, tourists who come to this Lion Street Step corridor and enjoy the location and the uniqueness of our neighborhood. So I do feel that we're frustrated. We feel it's your duty to protect this unique aesthetic character of our neighborhood, as we should of all San Francisco, but this is one like the Painted Ladies or the Lombard Street, curvy street, and it is one of those beautiful individualized aesthetics of San Francisco that we love. So please overturn this approval of this,
Thank you.
Of this facility.
Thank you.
Good evening. Thank you for your time. My name is Susan De Silva. My husband and I reside at 2550 Lion Street with our 3 young children. And I would like to address the aesthetic concerns we have. The telecommunications companies apparently believed that they had virtually absolute right to install new wireless facilities without complying with the aesthetic standard. They challenged, as you know, the aesthetic standard all the way through the California court system. And as we all know, they lost. The California Supreme Court recently upheld the ordinance as within the local power of the city to protect aesthetics. And it was a unanimous decision. The state appellate court specifically noted the importance of the city's power to protect local aesthetics and landmarks. Those opposing us seem to believe that these court decisions have no import. We disagree. We believe the reasoning of the state courts emphasize the inherent local power to protect aesthetics. Personally, we are deeply concerned about the aesthetics and the negative impact this proposed 5G wireless facility would have on this beautiful historic landmark in San Francisco. We want to preserve the character of this historic Lion Street Steps neighborhood. San Francisco's beauty is critical to its tourist industry and a reason people and businesses want to locate here. We thank you for your attention.
Members of the board, my name is Kathy Yu, and I own the house right next to Jeannie's. So my house will be about 100 feet away from this wireless facility. Respectfully, we believe San Francisco's ordinance imposes a duty to affirmatively protect aesthetics in each individual case. As we highlight in our brief, San Francisco's ordinance was clearly designed to require protection of aesthetics, including local landmarks such as the Lion Street corridor. As we emphasize, the ordinance requires the various departments to make affirmative determinations with specific explanations that each wireless location does not interfere with local aesthetics. The wireless companies and the city
Thank
appear
you.
to
You'll have
believe-
time
What
under
strikes me
rebuttal.
here is that using federal land, the Presidio is not San Francisco. Everything that happens on federal land is not applicable to San Francisco. The liquor laws are different. Everything is different. And the use of an address on federal land, to me, is it's a different jurisdiction, and has nothing to do at all. If you're either on federal land or you're in San Francisco land. Okay, so federal land is like another country. Really, I mean,
You give up your rights as a U.S. citizen. One, you go into. I mean, the same rules do not apply.
Yeah, the rules. But the rules on one side of that wall are different than the rules on the other side of that, and so the use of that address, you're in a different country, you're in a different jurisdiction, it's really sloppy. And
DPW, maybe we should.
Department of Public Works, and I think
So, but how do you read that? I mean, that we're now talking about an address that is on federal property, but we're talking about a pole that allegedly is in San Francisco. So the question to the planning department: is it in San Francisco or is it on the federal land known as the Presidio?
The pole is within San Francisco. It is subject to our jurisdiction and to our permit process, and our requirements have you identify the property that it is in front of. It's in front of the Presidio. So that's the property that needs to be identified.
So we'll move on to rebuttal. So you have 3 minutes.
Okay, quickly.
Overhead.
I think we can all agree that everyone sort of uses Google Maps, and it's pretty darn accurate. And this kind of shows the distance. It's not 2 blocks like Turk. It's over 2 miles. And, quite frankly, as we emphasize, the ordinance requires the various departments to make affirmative determinations with specific explanations that each wireless location does not interfere with local aesthetics. And maybe if Verizon had made a site visit, they would have seen the Lion Steps. The wireless companies and the city, it appears you're rubber stamping this, and you're making it routine. And in this individualized, what we're asking for is individualized consideration of the impact, just as the ordinance has. The courts have affirmed local power to you to protect the aesthetics. And the city ordinance imposes a duty to protect this unique character of each neighborhood, and we just simply ask that you do.
Thank you.
And I just want to continue and say that they have argued under, I believe it's Government Code Section 65010B, that this doesn't matter because no one's injured due to the error or the deception, and I would disagree. If this is approved, the very thing that makes San Francisco such a world-class city of sweeping views and historical significance will be injured. So that's one thing. I also just want to emphasize that the view corridor here is from the iconic Lion Street steps looking down towards the bay. And we walk the steps every day, up and down, and as do thousands of tourists and tons of school children and artists and photographers. And I mean, you know this. And the view will be impacted from many levels of these steps that people come to visit every single day and night to photograph and to be in.
Thank you. You still have 50 seconds if anyone wants to.
So in terms of the approval, the notices that we received, we've got the same notices from 2582 Filbert, 2735 Green, 2300 Filbert. All these approvals for these wireless facilities are exactly the same, with no differing in language, with no uniqueness. you get my point.
Thank you.
So we have a Thank motion you. from Commissioner Honda to continue this item to September 18th. On that motion, Vice President Lazarus? Aye. President Swig?
Aye.
Okay, so that motion carries 3-0, and we will see you on September 18th. We'll put you at the beginning. Thank you so much for your patience.